Thanks everyone for joining us. This Financial Poise webinar for the Startup Small Business Advisor 2024 series is episode 1. It's the very basics, forming the business. And as I said, it's part of the Startup Small Business Advisor 2024 series and is sponsored by Type to Learn, by Sunburst, Mood, and Max Asset. Slide 7 of the PowerPoint summarizes this episode, and slide 7 and 8 summarize the series. Speaking of the slides, we're not going to step through the PowerPoint or deck in any particular order, nor will you have to listen to us regurgitate any of the slides. This webinar, like all Financial Poise webinars, is an informal conversation on the topic of the day. You can keep the PowerPoint handy, however, because we may indicate what slides our conversation touches upon as we proceed. And if you've printed out a hard copy of it, you could use it to take notes. Our panelists are, and we're joined today by Leslie Cohen. Leslie is a principal at All Rise Legal Counsel in Chicago, where Leslie concentrates her transactional practice in securities law, corporate finance, and general corporate law. All Rise Legal Counsel helps its entrepreneurial and small business clients raise private funds, purchase or sell businesses, and handle their day-to-day business needs. We have Jonathan Friedland with us today. Jonathan is a corporate restructuring attorney with Much Shellis, based in Chicago. And Richard Claywell is with us. Richard is a forensic CPA. He performs his business valuations, economic damages, and forensic fraud investigations. He crunches numbers in lawsuits, and he testifies in litigations as an expert witness. I'm your moderator. I'm Robert London. I'm a partner at Jasmine Schlesinger Narendran LLP, which is a full-service law firm in Garden City, New York, which is a stone's throw away from Manhattan, New York City. My practice as a transactional attorney is M&A, venture capital, startups, exec comp matters. Basically, anything that's tough to negotiate and to fund a draft is what I do. We appreciate that you're not spending your time and money to hear our infomercials, as fascinating as they may be. Our full bios are at the back of the PowerPoint. This webinar is a production of Financial Poise. More about Financial Poise can be found on slide 40 of the deck. If you're attending the live webinar premiere of this webinar, you can submit questions using the portal. If you're watching this on demand or have any questions after the webinar, you can send an email to info@financialpoise.com. Remember, the PowerPoint conversation we're about to have are meant for general educational purposes and do not replace the need to consult with an attorney, an accountant, or appropriate professional. In other words, if you are silly enough to take significant action based on something you might learn today, don't blame us and come knocking on our webinar portal doors if things don't work out the way you had hoped. Once again, thanks to Type to Learn, Mood, and Max Asset. You can learn more about our sponsors on slides 3 and 4 of the deck. All right, let's get this party started. So since this is a webinar about startups, and throughout our discussion today, we're going to be talking about startups and how to basically get started on a startup, we're going to model our discussion as if we had in mind a particular venture. For today's business model, we'll think about having developed a low-tech iPhone or Android app that has potential large upside commercial characteristics. Let's pretend it's an advertisement optimizer for TikTok, as until when, or for however long TikTok is still available here in the United States. Let's start with Leslie. Leslie, our app development team consists of 3 friends, and they're at a Starbucks chatting about their plans to move forward and their great ideas. What sorts of problems might a non-partner legal entity of multiple ownership solve that a typical partnership does not solve? What are the difference as far as limitations on liability concerns for our coffee drinkers?
So you hit the nail on the head, which is that limitation of liability. If you don't form any entity whatsoever, then every one of those people on the team have potential personal liability. So if anything goes wrong with the app and there's a lawsuit, the people could come after their home, their bank accounts, their salaries, everything, all their personal assets. So you want to be 100% sure that doesn't happen and form some sort of an entity. If you form a general partnership, pretty much the same deal. So you want to find a type of entity that offers that limited liability under the law.
Hey,
Okay, so
one
let's
overlay, one overlay, if I may. So, the notion of limited liability with these entities is a presumption. It's a strong presumption, but it can be overcome. You know, there is such a thing as piercing the corporate veil. And so, um, one needs to, keeping it super short, you have to respect the formalities of the entity. You can't, start mixing your personal finances with the companies. That's a good way to blow um, the protection of limited liability. Um, Likewise, if you have ridiculously, if you're a surgeon operating through an LLC doing high risk surgery, merely operating through an LLC will not protect you against, negligent suits necessarily. There's all sorts of caveats to the default rule.
for business, I mean, as a general proposition, it will never protect anyone from fraud, obviously. And I think for revenue producing businesses, in many states, sales tax is a no-no. If you own an S-corp, for example, we'll tap Leslie shortly about what are some of the various menu choices we have when we're talking about entity selection. If you have a corporation and it doesn't pay sales tax, typically taxing authorities will look through to the owners of the entity. So as promised, let's move on to Leslie. What are some of the types of entities that are available, and what are some of the differences among those entities?
Sure. So, the probably the one that everyone's heard of the most is a typical C corporation. And that's, and one type of entity. Another is that C corporation can file something with the IRS to make an election to be treated as an S corporation. And then the other one is a limited liability company. And then there's also limited liability partnerships. And all of these different kinds of entities limit your liability, but they have very different tax consequences. And, for instance, another important point, I think, is that a limited liability company is the most flexible entity type, where the money that comes out and is distributed to the owners does not have to necessarily follow the percentage of ownership, whereas that's more difficult with a C corporation. And an S corporation is much more limited than both of the other types in terms of the types of owners that you can have with an S corporation. There's a limited on number of owners. There cannot be international shareholders. So there are a lot of different things to think about with those in making those choices. And then when you're making a choice, since we're focused on startups here, I think the most important thing to think about perhaps is in determining what kind of entity is whether or not you're going to be looking for investors down the road. And if you're going to be looking for sophisticated investors and you're going that route of raising, several different fundraising rounds and ending with perhaps a venture capitalist, they only invest in C corporations. And there's way too much to go into behind why that is, but it's just a fact. So typical question from clients is, we want to go that VC route. Should we start as a C corporation? There's depends on how soon you want to go. You want to, take that route of fundraising. You can always start as a limited liability company, which has some better tax benefits, and then convert into a C corporation. But again, that conversion can also be taxable. So you have to be careful about that. And then the last thing I'll say on this topic is that there's a huge tax benefit for people who invest into a C corp under Section 1202 of the IRS code. So if you're putting cash into a startup, you may want that startup to be a C corporation. So you see, there's a lot of different considerations.
Got it. Thanks. Let's talk a little bit generally about some of the shared attributes of first-time entrepreneurs and some of the lessons that she might learn. But John, can you describe some of these attributes and what are some of the lessons, let's say, a seasoned entrepreneur may have learned along the way?
Sure. Before I do though, I just want to make a note that, the example we're talking through is an example of sort of a scalable tech company that we can envision, as Leslie, brought up, might want to get outside investors and might ultimately, sell itself, big exit, that kind of thing. But startup doesn't necessarily mean a scalable company like that. An entrepreneur could be someone who starts a dry cleaning business like George Jefferson, or watch this. I'm using my knowledge of pop culture. Pops Racer, the founder of Racer Industries and Speed Racer, the self-made fashion icon, Jacobim Mugatu, if you know the movie, and of course the pharma mogul Tony Montana. Anyone get that reference?
Yeah. What about Unger Photography?
That's right. That's right. Felix Unger was absolutely a fantastic entrepreneur. So aside from being fictional characters, what do these men have in common? They were all risk takers, right? Willing to take calculated risks, able to navigate uncertainty, and make decisions on incomplete information, something lawyers hate to do. Each was highly motivated and had an incredible work ethic. They had vision. They knew what they wanted to achieve. They were innovators. They either looked for a new solution to an old problem, or they identified unmet market needs. Perhaps most importantly, in my view, is resiliency. One has to hear a lot of no's before getting to a yes. And just as one problem is being resolved, two more can pop up. Being an entrepreneur can be very much like playing a never-ending game of whack-a-mole.
Don't disagree. I think the other thing that I might add to that is you have to learn when to say yes and stop. You get something in negotiations and discussions that you've been after, you can end that line of inquiry and move on, right? Sometimes people have the need to push, even when they've achieved a satisfactory result. That extra question sometimes undoes a lot of ground gained.
A cousin of what you just said is the expression, what's the expression? Don't let the perfect be the enemy of the possible, or the enemy of the acceptable.
Mm-hmm. All right, we gotta listen to tap Richard, get some of his wise thoughts, and bring him in here. Richard, what are some of the questions an entrepreneur should consider and at least be able to answer intelligently and comprehensively before searching for capital? What are the arrows in their quiver that they should at least have ready?
Getting capital for a startup can be difficult. What you need to be able to document and prove to whoever the lender may be is, what is the purpose of raising the capital? Why do you not have the money yourself? When you get the capital, how are you going to, well, it depends on the type of capital, and we'll talk about that later on, whether it's going to be equity capital or debt capital. They're treated differently. So that's something that you need to think about. And how much do you need from a capital for your startup that you're going to have? What you don't want to do is to go out and do all the work that's necessary to get the paperwork in place and pay your CPAs and your attorneys the legal fees for all the stuff that's got to be done, and then you don't have sufficient working capital. So now you got to go back and dip in the well a second time, which is going to be difficult. You should have some idea of what you think your business is going to be worth. Not everybody knows how to do the valuations, but you're going to need to know the banks or the lenders or whoever are going to look for what can they receive on this if this thing goes south. Doesn't mean that it will. you need to look at what your return on your investment's going to be. Is within the valuation community, one of the things we want to take a look at is the return on alternative methods, the alternative investments. I'm sorry. But if I'm looking at possibly investing in your company and there's a very low return, and if there's a similar company that I could invest in that's got a higher return, I'm probably going to go with the higher return, more than likely. But we need to know what that return on investment is going to be so we can present it to people so they understand what we're trying to do and how we got there. And I personally believe the more sophisticated you are in putting your accounting, your valuation, and your legal documents in place, the better chance you have of getting some funds. I think also what we need to take a look at on seeking capital is what is our exit strategy going to be? How long are we going to be here? What's the term of that capital? Are we doing this for the long haul? Are we doing it for a 5 or 10 year period and then sell the company? We need to know where we're going when we first get in there. We need to know what the market opportunities are and what the competitive landscape is. Just because I've got a quote great idea doesn't mean I open my doors and everybody's going to come flooding in to purchase my product. So these are things we want to take a look at. These are things that we need to let people know that's going to give us some money. How are we going to do this? How are these funds going to be repaid? So those are some items that we really want to, that I believe we should really think about.
Thank you, Richard. I think the one thing that I would add to that on the last item that you spoke about, opening your doors and perhaps the base revenue model, an outgrowth of that is what's the barrier to entry? So if we're talking about something that's high tech or pharma, it's, do I have protectable IP? Is it something I can patent or copyright? To the dry cleaning store, the question is, what's the neighborhood look like? Are there other dry cleaners nearby? Am I getting a spot in a strip mall where my lease has a protection on that same landlord not allowing other dry cleaners in a 6-block vicinity? So barrier to entry is an outgrowth, I think, of the last item you touched upon.
I would agree.
Anyone else want to chime in? All right, let's keep it going, John. Before our latte friends get too excited about their initial business idea, what are some of the very basic steps that they should take?
Well, when the business is just an idea, and you just kind of talked about this, but I'll just put a finer point on it, maybe. The first thing to try to do is to validate or invalidate the idea. Your example that you chose to go with is funny. With what's going on with TikTok as we sit here on March 22nd, 2024, that it may be made illegal in the United States. If that's the case, if we were actually talking to these guys today, then the elephant in the room is, do you really want to devote the time and energy it will take to develop something that may be completely unusable within the the borders of our country? Then again, the technology may very well have other applications. Is the idea the proverbial solution? Moving on, solution in search of a problem. Has it been done before? And that's not to suggest that because it's been done before that we don't want to move forward. If we're these entrepreneurs, a lot of pretty famous first movers didn't win the race. Betamax came out before VHS. There's an excellent article on Financial Poise called The First Mover Advantage or Disadvantage: Why the Early Bird Doesn't Always Catch the Worm. The reason I can recall the title is it was written by an author who's as brilliant as E.S. Hansen. No, I wrote that article, but it kind of expounds on the point. In all seriousness, given that the example we've been talking about is very tech heavy, one of the more important first steps, and I'll leave it at that, I'll sum up, is to diligence the IP, including making sure that we want to make sure that it's not prohibited by existing patents, so that right as these guys get out of the gate, they're sued by somebody for patent infringement. That's bad.
I guess the other thing we might want to do is also do some very basic burn rate modeling to see how much we're going to need and how long it's going to last money wise. Or we're going to skip to money soon. And I guess our TikTok friends, our software engineer might have been able to do a model that ports over to Reels. Let's assume that going forward, so
Sure.
we don't get too dragged out into a political discussion on what's going on with TikTok. Richard, let's talk about the money. Show me the money, as the movie said. Our developers need capital. Please explain the principal differences among some of the entity types we discussed along the dimension of attractiveness. Let's focus on equity funders.
The equity funders, there's pros and cons for both equity and debt, and we'll talk about the debt in a little bit here. But the equity funders, you can get common stock, and I've actually got a case we're working on right now where a money guy puts the money into a company, and the operations guy is now in the process of buying the money guy out. But these are people that have money that they're willing to invest in a particular company. They've got voting rights typically that go along with that. And what that does is when you receive those equity investors, you wind up diluting or reducing your ownership percentage. And that is something that needs to be discussed. It's very, very important that in my mind, however y'all want to work it out, somebody's going to be in control. Somebody's going to have the ability to do whatever they want to do with the corporation or the entity that you have. And everybody needs to understand that so you don't have disputes down the road. If we have preferred stock, they have preference on any dividends that you might have. They would have some preferences on liquidation, and they may not have voting rights. So you need to look at whether you want to have common stock or preferred stock. There's also venture capitalists we can go to. These are individuals that will invest in your company. They're going to want a large ownership interest to get into that. And they have other people that are called angel investors, which are kind of the same thing, but they're looking for early stage equity interest in a company. So those are the types of equity loans that you can, or if you want to call them loans, the equity investor, where you can get your capital. And also what you can do is you can take for your smaller businesses, if we're talking about the coffee shop down the street, you've got in-laws that you can go to. You can go to your life insurance policy. You can go to the bank. There's just a lot of different ways you can actually raise some cash for your business.
Are there differences? Let's first look at common stock, then a preferred type investment. Does it matter which type of entity our app developers have selected? Like, could you do a preferred stock in an S-corp, or can you do a common stock in an LLC? Just the very basics. How am I limited raising capital depending upon my entity type, or am I not?
The stock is predominantly, well, it is for a corporation, whether it be a C corporation or an S corporation. And you're not going to see stock, at least I've never seen any stock in your LLCs, LLPs, those types of entities. The question in my mind becomes, can you have preferred stock in an S-corp? And people will tell you, no, you can't. But the actual answer is, yes, you can. We've done a lot of gifting type of work, and there's some specific requirements that will allow you to have a preference in the in an S-corp.
In an LLC, you could have, it would be a common membership interest. It wouldn't be called stock. It would be a unit or a membership interest, where you do have the mirror image or close to a mirror image of a common stock in a corporation would be a common membership interest in an LLC, or a common class of limited partnership interest in a limited partnership. So, but agree on preferred being somewhat of an issue to be considered in S-corps.
Right.
Anyone else before we move along and we keep beating up Richard?
Let me Oh, go
Let me,
ahead, Richard.
let me make a comment about that because this drives me absolutely crazy. And it's probably because I'm a CPA. But when you get to your software programs, a lot of those will say the retained earnings on a particular company, and your limited liability companies, limited partnerships, they do not have that. When you said member equity, that's what they should say.
If I could overlay, I'd like to just give a little bit of context. So once upon a time, before 1977, there was no such thing as an LLC at all. If you wanted to go into business, and assuming you didn't want to be a sole proprietor or partnership, you had two options. You could form an S-corp or a C-corp. By the way, S-corps are not that much older. S-corps were enacted just about 20 years before LLCs. But I digress. A C-corp certainly allows for multiple classes of stock that can divvy up economic rights any way they want, governance rights in a multitude of ways. C-corp's very flexible. I'm not sure exactly and I'm not taking issue, Richard, with what you said, but as a general matter, an S-corp, while it avoids double taxation, which is a good thing, it does come at the price of some modicum of less flexibility regarding the way you can slice and dice the economic and governance rights. As Leslie said earlier, with an S-corp, you can't have more than 100 shareholders. They've got to be U.S. citizens or residents, I think. LLCs have no restrictions on ownership whatsoever. And here's the thing where I'm not sure if we agree or disagree, but it may be parsing it too narrowly. But an S-corp can have voting and non-voting shares, but both have to have the same economic rights as each other. And in either case, it's the voting shareholders who have to elect the board. And then, of course, the board, for most decisions, is the governing body. The board appoints the officers and then the company runs, right? It's only the extraordinary things that shareholders have to approve or disapprove of. The main right of shareholders is to elect the board, or the most commonly used right, maybe. And an LC is just a completely different animal in terms of the flexibility it provides to let people own in just myriad ways, and to how it's governed. I don't know if that's helpful or what, but I feel better for having said it.
Okay. Richard, let's talk a little bit about debt. Our app developers are now looking at potential debt financing. Can you touch upon that for a little bit?
I can. The debt financing that we get is good from the standpoint that I'm not sharing my ownership interest in the company with somebody else. But it does come with that you have to make principal and interest payments on that. And it doesn't sound too awfully bad until you go look and see what happened when COVID came around. A lot of companies went under, and I think a lot of that had to deal with when there was a downturn, they could not afford to make the principal and interest payments that was out there. So we do have the principal and interest payments, and depending on when you go to the bank to get the equity, is going to determine what your interest rate's going to be. The higher the interest rate, the more payment. So that gets to be a potential problem for us. The debt financing has a lower cost, but it does impose financial obligations to it because we do have to repay the debt. And I think that's the primary difference is one, you have a debt structure that has to be considered, and on the financing, you do have the debt that you have to consider.
I can tell the listening public that I forget which episode it is of this series, we'll take a deeper dive into debt versus equity versus convertible debt versus something called the SAFE agreement, which we may talk a little bit about later because it is pretty basic and prevalent now, versus revenue share arrangements. There are all sorts of ways that startups certainly in tech and pharma. I'm not sure about our dry cleaning retail establishment would work for these other things, but there are a lot of potential avenues for financing out there.
Right.
Or at least different ways. The question is if the money is there, but there are different ways that it can be structured and funded. Let's say our app developers decide to start their collaborative business with each having an equal share of the business. I'm going to ask Leslie first about what type of problems of governance can we anticipate and how might those be addressed? And then I'm going to follow up with a question for John.
So this is, we're in a very fundamental startup discussion, right? And I think forming an entity is obviously number one to protect your liability, and number two, by far most important to me. I guess the an IP lawyer might argue that that's a big part of it too. But to me, the second most fundamental thing is having an agreement amongst the founders. So if there are only two founders, and they're 50-50 owners, there's a big problem if there's a disagreement, right? And depending on the state law, if you can't move the business forward together, and there's nothing talking about how, there's no mechanism in place for resolving disputes, you could actually end up in court in order to have to dissolve the company. It's expensive and emotional and time consuming and absolutely not what you want. So if it's a 50-50 issue, some of the ways you can deal with it, there's from the least expensive way would probably be, and the simplest, if you're a really early stage startup, both agreeing on a third party that you trust to be the decision maker. That would be one way to do it. Another way would be to just, go to specify arbitration or mediation first and then arbitration that's binding. And then the other way is something called a buy-sell. And the basics of that and the way it works is either owner can go to the other and offer to buy them out. And then the person who got the offer has two choices. They can say, yes, I'll sell for that price that you've offered, or no, I'm going to turn around and buy you out instead. And that incentivizes the person who's making the first offer to choose a really fair price, because it could turn out that they're the ones who gets bought out at that price. So those are some of the mechanisms. And then if you have more than two owners, you could leave it as, a majority vote to solve issues between you. But I think, something important to think about in that situation is, let's say there's, a third, 33.333 whatever percent of a company is still a significant amount. So does that owner, does each owner want a say in some of the sort of out of the ordinary things that happen in a company? So let's say, a sale of the business, or taking on debt or purchasing property. That may be something where each of the owners says, I don't want to leave that up to the other two to decide. And I want to make sure that that's unanimous. And in that case, again, you're back to really needing a document that clearly spells out how those disputes are going to be resolved.
The same type of buy-sell that you mentioned when you had two equal partners can be applied to three when the person with the blocking right, and we'll assume, let's say there are a list of major transactions. Actually, here informally at my firm, we have a long list of those. We call it the usual suspects, and we start from there and pair them as necessary. Those are the blocking rights. And if there's deadlock, the same deadlock mechanism that you suggested is triggered, where the person who is not on board with what the other two wants to do gets to trigger the same buy-sell scenario. John, Richard, anything else on the corporate governance aspect?
No, I mean,
Okay,
the
let's
talk about the buy-sell agreement just makes me think of a client I once had, Mo Green, and they wanted to buy him out, and he said, "You buy me out? No, I buy you out." I'm sorry. I'm mixing reality and real life again. I'm sorry. I didn't take my meds this
Alright.
morning. Go on.
Let me make a comment on the buy sell because we encounter this quite a bit. I think that people should go to an attorney to have these things drawn up. But I've seen many times where when you have a dispute, the attorneys will say that you're going to value a company at fair market value, which is absolutely fine. But then they go to proceed and define what fair market value is, which has absolutely nothing to do with what really fair market value is. So I would caution attorneys when you draft these things, just say fair market value, leave it at that. We know what we need to do with that. And I've actually had to take a couple of these to attorneys that are CPAs and attorneys and get legal opinions on what the definition of their fair market value was. I could not figure it out. So that's just some caution.
Well, in a well-drawn provision like John or Leslie would prepare, you might have a fair market value determination reference, but if there's an objection, there's another level which it would go to an independent appraiser or business valuation firm with experience in the industry. I've actually seen, and many times parties insist on naming a valuation firm that, at least as it exists today, would be acceptable for that purpose. So there isn't much guesswork and there isn't much litigation. And sometimes people try to punt like, all right, it's the book value of the company. Well, you could have a book value of the company and a company that's really good calculations. The worst possible. So leaving the ones that I do unless not all debates to be by the drawn document.
Hey, Rob, I don't know
Agree,
if you can, your internet is cutting out a little bit for a moment.
I'm
That's
not
better.
sure how to clear that up other than
Good. Guys,
speak
is that me
slower.
or-
Is that
or-
better?
No,
It's
you're
fine
right.
now.
It's good.
It was Rob before? Okay. We didn't hear the last 10 seconds of what you said.
Okay. All right. Well, it was important. We're going to move along. Basically,
All right.
you would have an independent appraiser already provided. Let me see if I can close some apps.
I think you're okay now.
Yeah, I think so.
Okay, good. Oh, all right. I'm going to stop sharing the screen because I don't know if I lost the deck. Is the deck still there?
It's there.
Okay, good. Okay, I was saying that in response to Richard, that a well-drawn provision would typically not just say fair market value. If there was a dispute on fair market value, we'd probably have an independent appraiser mechanism there to close that gap. Let's move along. I'm going to tap John to briefly talk about how intellectual property rights might be handled in the startup. Let's say of our three entrepreneurs, one had the idea for the business plan, the other one is the coder, and the third one, let's say, is in marketing. How does the entity move forward based upon these various ideas and intellectual property development scenarios?
Well, it'll be situation specific, of course. I mean, if one of the founders actually, owns the IP, then that gives rise to even a half decently trained lawyer identifies that right away as a conflict issue, because the interests of the founders, diverge in that point, and separate counsel would be necessary. But I don't think that's where where you want me to spend my time. But it wouldn't be uncommon for a founder to own the IP, and in that case, the owner, look, that may be that founder's contribution to the company, but it also may be that that owner licenses the IP to the company. But you raise, I don't know if it's intentionally or not, but you raise a different related and broader issue. Even assuming all the founders have the same rights in the IP, they just decide among themselves that that's the case. It would not be uncommon at all to have the IP, and I would suggest it's best practice, all else being equal, to have the IP owned in a separate legal entity from the rest of the company. So you got sort of like an IP holding company, and its only purpose is to house and manage the IP assets. And the primary reason to do that goes to sort of quarantining or isolating that entity from potential liability. So if creditors of the main operating company sue the main operating company, or if the main operating company otherwise has some other issues, that puts its solvency into question, the IP in the separate company has a level of protection. Separating out like that can also help with monetizing the IP, because it may be that the IP is valuable to the company, the business being founded, but it may also be licensable to other businesses in non-competing, completely different industries, etc. And if you've got a separate entity, you could have people in that entity who really can focus on monetizing the IP without having to worry about the day-to-day core business of the company.
How do you handle the scenario where we've gone through a couple of rounds of friends and family financing and the professional venture firm comes in? I mean, won't they typically insist that the issuer then own the IP? Does it get folded in? Or is there some sort of ironclad lifelong license to the core business, because they're going to want to have something that's sellable as liquidation protection for their preferred stock, Series F going in, for example?
Yes, no, everywhere in between. I mean, it's simply a matter of negotiation, who's got leverage. But what you said is right. If from the perspective of anyone who's putting in the money.
Okay. Anyone else on this topic? We're going to bump things along to Richard. We talked about corporate governance, where hopefully the parties always get along, or what happens if they don't get along. What happens if one of our three founders decides that they want to retire and go play golf, or God forbid they die, or they just decide they want to do something else, or they commit some sort of corporate theft from the company? How are things like that handled?
Hopefully they're handled by the buy-sell agreement that's been drafted. Unfortunately, I see a lot of times where a lot of the legal paperwork is not done, especially for your smaller businesses. But if you want to retire, what does the agreement say? There should be some sort of agreement. It's going to specify who's going to control the company, what percentage of business you're going to sell, which typically is going to be all of it. It's going to give you some guidance on how you determine what the value of the company is. And somebody a while ago mentioned book value. And I would suggest that is totally incorrect. Typically on your book value, what you're trying to do is drive down your taxes. So you're making elections, and you got to do everything legally, but you're doing everything you can to reduce that value. And now the opportunity comes to sell, and now you're saying, no, I don't want to do that. So that poses some particular problems that go along with it. But the buy-sell agreement is where you need to go to find out what is supposed to be, and what it takes, what the conditions are, if there's payout terms. If you commit fraud, a lot of times there's provisions that say that if you are a fraudster, then you're just going to be kicked out and you're entitled to nothing. So that needs to be, or should be, addressed in there. You also have the issue of Texas is a community property state, and we're one of six that has community property. But something to think about, because we've encountered this quite a bit, is the husband shareholder dies, and then you've got some insurance. That insurance goes to the corporation, and I've had at least one attorney tell me that he would rather wallpaper his office with the stock certificates than to give the wife a penny. And so now what winds up happening is, because i.e. new owner has control of the insurance funds. Nobody has addressed what's supposed to happen with this. Then the wife, possibly with children, has no source of income. They can't get their hands on the insurance benefits. So now they have to file a suit. And so that brings up a lot of questions. I don't know of very many attorneys. As a matter of fact, I don't know of any attorneys that are willing to work for free. So now this individual that's destitute has to try to figure out how they can access the insurance funds that may be worth millions of dollars that they really have trouble getting their hands on.
Thanks. I mean, we've talked a lot about various provisions in the agreements and the like. I think I'm going to avoid talking more about those because I'm pretty sure future episodes are going to take a deeper dive into that. And since we're blessed with having Richard, who's a CPA on the panel, I'd like just to tap him a little before we bounce around a little bit more. What are some of the basics when it comes to tax planning? Because from my experience, sometimes I'm presented with startups that have been started up for a while, but didn't consider, made some wrong decisions at the outset as far as what state they're going to be organized in, what their entity is. What are the basic things to consider, coupled with the cautionary tale that it's never too soon to start talking to someone like Richard about these things?
Before you go there, I'm sorry. I just wanted to go back for a second because there's a whole, I agree with everything Richard had to say about, when you asked about a founder exiting a company, but there's a whole different level of concern that arises. And I think we'd be remiss not to touch on it. So I'm sorry, you're probably gonna have to kind of repeat your question in a minute. But I think that question, whether intended or not, also raised the specter of corporate succession planning. And I whether or not it was implicit in the question, I heard it to say, what happens if the founder exits, and the founder had a very active and important role in the company immediately before the exit. And that absolutely, raises the need for succession planning. It's an entire industry unto itself. And I don't mean to hijack, but I just want to say that for a company to be investable, even, it's got to have succession planning in place. And that includes making sure that, a designated person is lined up to fill the vacant role, or a clear process to fill the role exists. And it also means it's not just about sort of the top one or two people that sit in the corner offices. With startups, notoriously are thinly staffed. And when someone leaves at any level, a lot of knowledge can walk out with that person. And so it's important to think about building in some redundancy at various levels of the organization. I can tell you the companies I own, we take that really seriously. And documenting processes, having plenty of training videos and how-to memos so that, when someone exits, the business doesn't come to a screeching halt. Okay, I'll shut up. Sorry.
Yes, I agree with that 100%. Okay.
Well, thank you very much.
At the outset, day one, that's not much of a consideration. It's more of a consideration as to there's some initial success, and now you're raising more money before the serious money comes in. You're sort of you end up at that jumping off point, which is at what point when you're raising the serious venture money, will the venture capital say, well, it's no longer right that the founders are in control of this thing. They founded it. They've done it. Now it's time for a professional CEO, and maybe succession in that scenario is maybe a little bit less difficult if the founder who's given his business plan and his special sauce to the company already, succession planning is not such a big deal. But there's that tweener stage where it is a big issue before it's not just a question of managing, hopefully, a growing dynamo. All right, Richard, As the Marx Brothers said, I think duck soup. It's time to take up the taxes. No, it's just take up the carpet. No, he's right. You can't take up the carpet until you take up the tax.
One of the things I always recommend to people is if they have a question on anything whatsoever that's a legal issue, go talk to an attorney. I am not an attorney, and the client's typically not an attorney, and they don't know what they're doing. They're going to get themselves in trouble. And this is a real good area of taxes to get yourself in trouble. So I recommend that what you do is you hire a CPA that's familiar with what taxes are. Saying that, and I make this comment all the time to my staff, that not all CPAs are created equal. And actually, I made that comment in a deposition about a month ago, and the attorney told me, yeah, I agree with you, and he kind of chuckled. So I don't know what that means in real English. But they need to understand what the tax laws are, and they're not going to initially, so they have to get with somebody that understands that. So get with a CPA that's got some experience, that really understands what those tax laws are, and specifically how they relate to the geographical area that you deal with, because it's not just federal taxes you have to contend with, but you may have some state and local taxes that you may be surprised that never even existed because you've never been in business before. The legal entity that you're going to use, and we've talked about several different types of legal entities, they're not all taxed the same. So how do you tax these? So this is part of making a decision on what type of entity do I want to be. Do you want to be a C-corp? Do you want to be an S-corp? You want to be a partnership? And they're all taxed just a little bit differently. So I need to understand that so that I don't get myself in trouble. We also want to understand what the deductions are, what we can and we cannot deduct, i.e., a lot of times individuals will live out of their corporations or their companies, whatever they happen to be. Paying for my kids' college while they go to school. I run it through the business. I buy my groceries and I run it through the business. I do my house repairs. I run it through the business. And that will get you in trouble in a heartbeat. If you're ever audited by the IRS, you're going to pay some substantial penalties for that. So get with your CPA and understand what you can or cannot do and follow those guidelines. You're going to have various reporting requirements for federal taxes. You're going to have payroll taxes that you have to contend with. You're going to have some different county taxes. Understand what those taxes are, understand what the due dates are, and make sure that those are filed on a timely basis. You may have an audit with the IRS. To me, and I've had clients do this in the past when I did a lot of tax work. Well, it's one of the IRS. I know what I did. I can handle it myself. And to me, that's almost like practicing law. You don't understand what the tax laws are, you're going to get yourself in trouble. So just make sure the individual that you deal with understands how all this stuff works. You need to understand it so you're on top of it. You're the individual that's going to be responsible for it. So it's difficult to point a finger at somebody else and say, well, they should have done this. So get you a good CPA, make sure you understand what you're supposed to do, and do everything on a timely basis.
By the way,
Thanks a lot.
by the way, circling back to something we talked about earlier, if someone's stupid enough to run their business the way Richard was describing in terms of like a personal piggy bank, it's not just the IRS. I mean, that's like fantastic evidence to pierce the veil, and the idea that it's a separate legal entity, probably goes out the window under those facts. So you just wasted, you didn't even need to bother spending the money you spent to incorporate.
Agreed.
100%. Yeah, I agree.
Let's close with a couple of more topics. Leslie, how about some basic guidance for a young company to go out and get equity financing? We have this idea, we've contributed our IP to the company, we've formed it, we had a decent lawyer, gave us a great deal on a startup package. Now we need money. How do we do it?
So, the easiest thing is to reach out to friends and family. That's a no-brainer. And there are certainly negatives to having friends and family investors because, you probably feel terrible if they lose their investment. They may not be familiar with sophisticated investment tools that are typical for startups like safes. So that's one route. The other is, tap your network. You should have a lawyer, since you're going to be using a lawyer anyway, you should choose a lawyer that has, that specializes in startups and that has connections with potential investors for you, or at least can guide you to, to helping find those investors. Talk to your accountant about potentially having investors, that they could reach out to. I mean, I know I have a whole database of people, of potential investors broken down by, different industries that I make introductions for my clients to. The other thing is that there are, I think Richard touched on earlier, early stage investors called angels. And you can just Google and find angels that are focused, but you don't just look for general angel investors. You want to look for people who are focused on investing in your particular industry. And then a lot of them also have geographic concerns. So they want to make sure, like in Chicago, there are a bunch of angel investment groups that only invest in Chicago-based or Midwestern-based startups. And I think that's true all over the country. And then the other possibility is crowdfunding. There are crowdfunding platforms that you actually have to use if you're going the crowdfunding route. And unless you're doing a general solicitation offering, which is, I think, a little more complex than we're getting into in this session. But the one other thing I do want to say is that I was recently speaking at an angel investor event, and there were a bunch of investors there, and they were very adamant that a no one time is not a no forever. So if you do identify an investor that you think would be a great fit and you get a no because you're so early, stay in touch with them, send them updates, send them, anything great that's happening with your company, because a no doesn't mean a no forever.
Boy, it sounds easy. John, how about a reality check? What really happens? Or does it happen just like that?
Well, it can happen like that. I don't disagree with anything Leslie said, but things vary a great deal. And again, are we talking about startup as in, startup, Shark Tank, VC, sexy, businesses that can really scale? Or are we talking about, the laundromat, the restaurant, the whatever? So things really vary greatly. You want a regular loan for your business as a new business owner? Where's your collateral? You willing to put up a personal guarantee and a personal financial statement? You want silent partners? Better realize there's security law issues that need to be dealt with. Fundraising can be a full-time business, and at the risk of causing a disagreement we won't be able to solve in this webinar, I happen to think crowdfunding, in the true sense of the word, meaning for non-accredited investors, is horrible and evil. And I think I happen to think that any company that chooses to raise money via crowdfunding from non-accredited investors is desperate by definition. And maybe that'll be an episode of some other future webinar. There's a lot of writing on financial poise about that. There's a whole series of articles called like Alternative to Assets or Credit Investor 101. And this view is espoused. But reasonable people will disagree, for sure.
All right. Well, that about gets us through our time. I want to thank everyone. I think the takeaways here are, at least for our, the basics are picking the right entity, doing your tax planning, thinking about your IP and how to protect it, addressing issues, and basically understanding how much you need to raise and what your burn rate's going to be. Now, thank our sponsors again, Type to Learn, Mood, and Maxset. And that's it for now. Thanks for joining another entertaining and educational production of Financial Poise. You can look for Financial Poise wherever, Financial Poise webinars, wherever better continuing education webinars are sold, you can join me again on April 2, which is just around the corner, for episode number 2 of the Startup Small Business Advisor 2024 series. There, we're going to be talking about raising capital and negotiating with potential investors. And as I hinted, we'll be taking a deeper dive into some of the topics that we just barely touched upon today. Anything else from any of the panel before we sign off?
Thanks for having me.
Thanks for having me
All right.
too. Appreciate it.